expressed by my international sisters. It is an honor and privilege to participate in this inspiring and historic summit on a significant issue that is critical to the safety and security of women and girls. Although I have been involved in the criminal justice system for over 40 years, as a prosecutor, defense counsel, and judge for 28 years, I have not had direct experience with a human trafficking case. I have had considerable experience with cases which involve the exploitation of women and girls, which is, of course, the essence of human trafficking. As a prosecutor, I saw women addicts who were in abusive relationships recruited to participate in drug trafficking organizations. As a criminal defense counsel, my first client was a heroin addict who did what addicts do, robbed and prostituted herself to feed her insidious habit, a perfect target, ripe for exploitation. As a judge presiding exclusively in criminal matters in an inner-city courthouse in Toronto, dealing with all women in custody, I am exposed daily to women who are the subject of physical, sexual, and emotional abuse. The women I see are often the victims of the feminization and criminalization of poverty, who are involved in prostitution and human trafficking to support families, to cope, to survive. I frequently preside in a dedicated Aboriginal court. Aboriginal women have unique multiple rehabilitative needs as a result of the effects of cycles of violence and abuse, alcohol and substance addiction, and economic and social deprivation. Aboriginal women are frequently exploited by both individual traffickers and human trafficking organizations. It is in this context that I'm pleased to address you with respect to Canada's progressive initiatives, particularly as they pertain to the victims of human trafficking and enhanced evidentiary provisions. In 2002, Canada ratified the United Nations Protocol to prevent, suppress, and punish trafficking in persons. In response, Canada enacted federal legislation to combat and prevent trafficking in persons. In terms of criminal law, the Criminal Code specifically targets trafficking. These provisions came into force in 2005 and have been updated in 2010 and 12. There is a global prohibition on trafficking. A victim's consent is never valid, as exploitation is the essence of the offense. The appellate decisions make it clear that the legislative intent behind the Criminal Code was to criminalize exploitation, which is assessed on an objective basis. Exploitation is defined and does not require direct exploitation. The code outlines factors that a court may consider when determining exploitation, including use, threatened use of force or coercion, deception, abuse of a position of trust, power, or authority, and organ and tissue removal. The primary trafficking offense is punishable with a maximum of 14 years or life under aggravating circumstances, with mandatory minimum sentences for offenses involving children. There are also prohibitions with respect to the receipt of financial or material benefits and withholding or destroying documents to facilitate a trafficking offense. Offenses of trafficking were added to the list of offenses committed outside Canada for which Canadian citizens or permanent residents may be prosecuted. Trafficking can now form a basis of a warrant to intercept private communications or take bodily samples for DNA analysis. Convicted traffickers are permitted inclusion in the sex offender registry and can be declared dangerous offenders. There are a number of evidentiary and remedial provisions in the Code designed to foster witness protection, including the ability to provide restitution to victims who are subjected to bodily or psychological harm, and provisions extending witness protection to children when testifying. Judges may exclude the public from a courtroom where a witness is under 18 in proceedings where an accused is charged with trafficking. Judges may permit testimony from outside the courtroom or behind a screen. Since Canada ratified the UN Trafficking Protocol, significant progress has been made at the domestic level to prevent trafficking and to prosecute traffickers, as well as to protect victims across and within Canadian borders. Canada is recognized as a Tier 1 country in the annual U.S. Department of State report. I've briefly outlined the relevant sections with respect to the prosecution of traffickers, and I propose to highlight a few federal initiatives with respect to the protection of victims of human trafficking. The Federal Victims Fund supports projects that provide services to trafficked persons and underscores the need to identify and protect at-risk individuals. The government released a national action plan to combat human trafficking, to introduce aggressive new initiatives to prevent human trafficking, identify victims, protect the most vulnerable, and prosecute perpetrators. Federal commitments under the National Action Plan utilize the internationally recognized 4Ps approach. As I live and preside in Ontario, I will now focus on the recent initiatives instituted by the provincial government to combat and eradicate human trafficking. Ontario is a major center for human trafficking in Canada, accounting for more than 2/3 of the cases nationally. Of Ontario's reported cases of human trafficking, most are for the purpose of sexual exploitation, and the majority of survivors are Canadian citizens or permanent residents. In Ontario, Indigenous women and girls are among the most targeted and overrepresented individuals. In 2016, Ontario instituted an anti-trafficking strategy to increase awareness, enhance justice sector initiatives, and improve survivors' access to services. The approach focuses on 4 discrete areas: prevention and community supports to increase awareness with respect to the causes of human trafficking and improve victim services; enhanced justice sector initiatives to support intelligence identification and investigation of human trafficking; Indigenous-led approaches. As indicated, Indigenous women are overrepresented as victims of trafficking and require unique support. Culturally relevant services and responses have been designed, developed, and delivered jointly with Indigenous partner organizations. A provincial coordination and leadership office has been established to improve collaboration across law enforcement, justice, social, health, education, and child welfare sectors. The strategy is survivor-focused. In May 2017, the Anti-Human Trafficking Act was passed, which comprises two statutes. The Human Trafficking Awareness Day Act, which proclaims February 22nd as the annual Human Trafficking Awareness Day. The Prevention and Remedies for Human Trafficking Act. The sections which provide significant and innovative remedies for victims come into force on the same date as the regulations, which have yet to be proclaimed. The legislation incorporates the definition of human trafficking and the enhanced evidentiary provisions of the Criminal Code. However, the legislation does not require either a charge or a conviction. The legislation creates a process for victims and others to apply for a human trafficking restraining order. The court may make such an order if the court determines on reasonable grounds that the person against whom the restraining order is sought has engaged in or may engage in trafficking of the victim. The court may consider a number of relevant factors, including the ages of the victim and the respondent, the victim's immigration status, whether the victim has a physical or mental disability, the nature of the relationship, whether the respondent is in a position of trust, power, or authority, the use of threats, intimidation, force, deception, fraud, or coercion, or the provision or withholding of alcohol or a drug, the respondent's control or threatened control of the victim's finances, personal effects, or documents, the possession, making, or transmitting a visual recording of the victim's sexual organs or the depiction of sexual activity. The legislation provides for the application of special evidentiary rules regarding witnesses. The court may receive and base its decisions on evidence considered trustworthy in the circumstances. I am a proud Canadian and honored to be a member of a justice system that serves as a beacon of hope to many jurisdictions globally. I've been inspired and enlightened by the insight and experience of my impressive international sisters, many of whom I'm fortunate to call my friends. Together, I am confident we will capture the spirit and purpose of the summit. We will make changes and improvements in our respective countries, learn from each other's best practices, and work collectively to improve the position of women and girls. As Pope Francis eloquently stated in his memorable address to the UN General Assembly in September 2015, many grave problems remain to be resolved. The classic definition of justice contains as one of its essential elements a constant and perpetual will. The women who have participated in this summit have clearly demonstrated the will to address the grave problem of human trafficking and slavery. Thank you.
Mrs. Besser.